My name is Lovemore Mutasa. I'm a law student at African University. My lecturer is Mr. N Maphosa. I'm going to talk about delict relating to sexual intercourse into marriage. I will start with the delict of adultery under common law and customary law. I will start with the delict of adultery under common law. The delict of under common law adultery is defined as sexual intercourse between a married person and someone other than his or his spouse. The claim for adultery damages. Adultery damages are claimable under two distinct heads under common law. That is contumalia and loss of consortium. I'll deal with contumalia first. Contumalia incorporates indignity, hate, pain and suffering which the plaintiff suffers. And consortium deals with loss of companionship, love, and services of the other spouse. So adultery damages are claimable under those two distinct heads under common law. It's not advisable to claim them under one lump sum figure. You have to show damages for contumalia and damages for loss of consortium. What are the factors considered in quantifying damages for the adultery? Normally, the courts weigh aggravating factors against mitigating factors, and those factors were loosely stated in the case of Nyakudra versus Washaya, 2000 case, volume 1, Zimbabwe Law Reports, at page 653. That is the High Court. In this case, it was held. The factors which are considered were the character of the woman and the men involved, the social and economic status of the plaintiff and defendant, whether the defendant has shown contrition and has apologized, the level of awards in similar cases, the decrease in value of money, whether the plaintiff has suffered lack of consortium as well as contumalia. So in other words, adultery damage will be increased where the adultery resulted in the breakdown of the marriage, where the defendant did not apologize and has not shown contrition. What are the defenses which are available to the defendant? Maybe the defense are the defendant did not know that the woman was married, or the other party was married, or the plaintiff connived with adultery, or there was rape. There is, in South Africa, the courts have actually, the Constitutional Court in South Africa has abolished adultery damages. In Zimbabwe, we have a test case. That is the case of Njozi versus Matione, in which the defendant raised a constitutional issue that adultery damages are unconstitutional. The High Court ruled that adultery damages are not unconstitutional because they are there to protect the sanctity of marriage. This case has been appealed against. It's now before the Constitutional Court, and we are still awaiting the Constitutional Court ruling on whether adultery damages are unconstitutional or not in Zimbabwe. So I've dealt with adultery damages under general law. Under customary law, Adultery damages are not claimable, but not under those two distinct heads of contumalia or loss of consortium. They are just one has to claim just a lump sum figure. And under customary law, a woman cannot claim for adultery damages because customary marriages are potentially polygamous in nature. That is why a woman cannot claim for adultery damages under customary law. And there's a case in Zimbabwe, a Zimbabwean case. That is Gwatidzo versus Masugusa, 2000, volume 2, Zimbabwe Law Reports, page 400, which in this case was held that a woman cannot claim for adultery damages under customary law. So I have the factors which are considered aggravating or mitigatory are the same with common law, whether the adultery resulted in breakdown of the marriage, whether the defendant has shown contrition or apologized. So I'm going to deal with now seduction damages. Under customary law, I'm going to deal with the seduction damages under common law and adultery damages under customary law. Under common law, a woman can claim for seduction damages. Seduction damage is defined as having sexual intercourse with a woman with her consent, and the woman has to be a virgin. There is a presumption that in a married woman, a married girl is a virgin, and the onus is on the defendant to show that she was not a virgin when he had sexual intercourse with her. If the seduction resulted in pregnancy and the child is born, there is the issue of paternity. And if the man admits having sexual intercourse with the girl, there's a presumption, a rebutted presumption that is the father of the child. And the onus is on him to prove that he cannot be the father of the child. This is adultery. These are seduction damages under common law. But there is the view that seduction damages, claim for seduction damages is archaic. Some are arguing along those lines because of the element of consent. Some courts are now doing away that with the issue of seduction under common law. It's a gray area. Our courts have not ruled otherwise. I'm now going to deal with the breach of promise to marry. Under common law, there's breach of promise to marry. They are contractual and delictual. So damages are claimable under both contractual and delictual damages. And if it's claimable under delict, there's this element of insult as well. That is under delict. And under contractual damages, for instance, whether the breach caused loss of income, maybe there were some gifts which were exchanged, the chain of those gifts, and so forth and so forth. Under common law, under customary law, the colonial courts ruled that a claim for breach of contract is unknown under customary law. But our post-independent courts were awarding damages for breach of promise to marry. This is a gray area, and I'm sure our courts are going to clarify whether the courts under customary law, this delict, there is such a delict under customary law. But of course, we are awarding damages. As I've said, it's a grey area. These are my submissions on delict relating to sexual intercourse and to marriage. Thank you.